So is Donald Trump running out of defenses? And is Donald Trump, maybe more importantly, with his lawyers, planning for a criminal trial? Is Eric Hirschman a reliable witness in all of this? That lawyer that said, Mr. Trump, you can't have those documents in Mar-a-Lago. Is he reliable? Will prosecutors actually indict a former U.S. president? Those questions came back today, but they came back with a vengeance. I'm joined by Andrew Cherkasky. He's on the right. He's an attorney, a former JAG lawyer and a former federal prosecutor. And Katie Cherkasky is an attorney and a former federal prosecutor. And yes, they have the same last name because they are married. So, Katie, I'm going to begin with you. This whole Eric Hirschman business sort of landed with a giant wallop. And all I could think was, like, that's the guy who's going to say he can't say he didn't know because I told him. So I guess the question is this a mic drop for the DOJ?
I personally don't see it that strongly. I think that it was good advice that Trump would, in fact, face some legal problems if he kept these documents, which did turn out to be the case. But I don't think that Eric Hirschman's conclusion that he wasn't allowed to keep these documents is the final word on that. I mean, that's really the ultimate question here in terms of the executive authority and in terms of the declassification that may or may not have occurred. So certainly it's some evidence for the DOJ that he was given this warning that there was a question about the legality of his actions, and that can play into the case. But I don't think that it's conclusive in any way.
So I only need to push back on that. And I'm not a lawyer, so you know way more about this than I do. Whenever we get into cases, when mens rea is the issue, what was the criminal thinking? Was there a guilty action that the person knew he or she was committing? That's the hardest thing to prove because you can't get in someone's head. You just have to find the witnesses to try to get in there for you by the actions that were, you know, at the same time. And so with a lawyer who could lose his livelihood and be disbarred and then maybe go to jail, you know, if he perjures himself. Isn't someone like that who goes on the record, and I'm not saying he's on the record right now, but he could be, isn't that stronger? And isn't that really hard for Donald Trump to surmount when a lawyer, his own lawyer, says, oh, no, he knew. He absolutely knew that was all wrong. He can't claim he didn't know that they were there or that they were classified or that they weren't declassified or that they were, you know, had been moved there. I told him. Isn't that really, really strong? Isn't that what they call that smoking gun?
Well, I'm not saying that Eric Hirschman didn't actually say those words to President Trump. I'm just saying that even if he did, that doesn't mean that the fact that he told him you can't have those documents is in fact true, because there's this whole debate about what President Trump's authority was to declassify, retain executive branch documents while he was in office and then keep them obviously after his time there. So certainly if he is telling the truth, that does in fact give some evidence to the DOJ that, hey, we had this conversation and President Trump responded or didn't respond in whatever way he may have done. But ultimately, it's not conclusive to the issue of what was his authority, because Hirschman thinks he can't keep them doesn't make that so. It's a constitutional issue. And ultimately, I think the Supreme Court would need to weigh in on it.
That's fair. And the people who would ultimately have to decide all this aren't lawyers, and they're not fancy legal thinkers. They're, you know, bartenders and mechanics and sometimes journalists, et cetera. They're just average Americans who this all has to be explained to. So, Andrew, if you're going to say it's a reasonable man standard, right? A reasonable man in Donald Trump's position would have or should have known what was right or wrong at that point. Wouldn't you then have to, if you're Donald Trump, say, I had all these other lawyers who told me the exact opposite? Or Andrew Hirschman is XYZ bad. You know, you'd have to discredit that lawyer. Or Eric Hirschman, you'd have to discredit that lawyer so that the jurors might think, oh, so he got advice from somebody he thought was a criminal or somebody he thought was, you know, a terrible, terrible person. Isn't that the kind of evidence you'd have to bring forward? So we'd have to know who those other lawyers were who gave him the opposing advice?
I don't think that's quite the question that will be asked. I mean, ignorance of the law is generally no defense to a criminal case. And so ultimately, I see it more of a question of law. Does the president taking documents out of the White House amount to something that could even be against the law? So it's not so much what Trump was told, in my view. It's much more about what ultimately the legal standard is. And since this isn't something that's ever been tested before, it's something that I think has to go to the Supreme Court. We know what the answer would be if it was anybody else in the executive branch, anybody else who had a security clearance, they would be guilty of removing classified documents. But it's so much different with the president because of the unique authority there that I think that this is a question of law that the Supreme Court needs to answer as opposed to jurors. And now that we have essentially the special master weighing in today, asking Trump for that assertion that these were declassified, I think it muddies the water even further. And it's ultimately going to be a question that continues to go up the chain of the courts to ask really not whether he made a mistake in the interpretation, but whether he could have done it inherently in the first place.
So that's a good segue to sort of hit up that topic now, and that is this request. Let's remember, Katie, that the special master is the handpicked choice of Donald Trump. You know, he got to submit 2 names, and the DOJ got to submit 2 names, and they went with this one, the one that Donald Trump had submitted. So it's his pick. And today, that special master, Judge Raymond Dearie, asked Donald Trump and his lawyers, okay, then let's just get this settled. Let us know which documents you declassified and when you did it, and we'll just move right on with it. And that we could dispense with so much of the silliness. And they said no. They said, not the time, not the place, maybe later. So, okay, and here's what the DOJ said to that. Trump's team principally seeks to raise questions about the classification status of the records and their categorization under the Presidential Records Act. But Trump's team does not actually assert, much less provide any evidence, that any of the seized records bearing classification markings have been declassified. So 2 questions for you, Katie. Wouldn't it have just been kind of the thing to do to say right there, if you're Trump's lawyers, for heaven's sake, here's the evidence. My client has been saying it all along. Instead of, we don't want to say that now. We want to preserve that for a defense we might have down the road. And then also, they would not say the words either, right? Like lawyers on the record in court wouldn't say these things are declassified. Most people who look at that case and really don't like Donald Trump say it's because the lawyers can't say something and perjure themselves in court. The documents aren't declassified. What do you say?
Well, it's such an interesting development in this case. And I think that it's a perfect example of be careful what you wish for, because you just might get it. And Donald Trump has now put himself, or his lawyers more aptly, have put themselves in a position that really is very disadvantageous. And it didn't need to be this way. So essentially what happened is this. If Trump was under this criminal investigation and he were indicted, he could then proceed to go to trial and have the DOJ prove beyond a reasonable doubt that he did not declassify these documents. And that would have been a very high hurdle for them because of all these constitutional issues and executive privilege issues. And Donald Trump would not have been compelled to make any statements or make any showing that he declassified. I mean, he may have done that, but he certainly wouldn't have been obligated to do so. But because of this request for the special master, essentially what the special master said today is that this is now a civil forum. You are the plaintiff, and now you must present evidence. You have the burden to show that they're declassified. So it's very interesting. I think strategically, as a defense attorney, criminal defense attorney, you can see the lack of strategy here on Trump's defense team, because what they're trying to say is we don't want to have to raise our defense. And in a criminal forum, that is very common advice. And you wouldn't want to show your hand or your defenses before you have full access to all of the evidence against you. But he's now back up against the wall. Because it's
yeah,
a
but then you
forum.
can't ask for the special master, right? Because they're calling,
exactly.
Well,
so they never should have done that, in my opinion, but well, they certainly did. And I think the judge honed in on exactly what the crux of the issue is here.
They might be building the plane as they fly it, though, not being able to see this many steps in advance. I mean, this is all kind of unprecedented, right? So okay, Andrew, a lot of times I keep thinking, and maybe it's because I forget so many details. There's so many to sort through. I keep thinking, who cares at this point whether they're classified or not? I mean, other than the danger part. Legally speaking, who cares? Because isn't it just about the Presidential Records Act in 1978? I think went into effect in 81. You just can't have documents. Whether they have yellow markings or red markings or fuchsia markings, you just can't have them. That they belong to the government, not to the man. Why isn't that the big discussion? Why is it all about did you declassify, didn't you?
Well, because I think that's what is really the most criminal of it, potentially. I mean, if it's just a records debate, if we're just talking about whether he can keep a souvenir or whether the souvenir goes to the National Archives, I don't think that that's very compelling to either base. And so I think both sides, both the Biden administration and I think Trump, both like this fight. I think that this is revving up the people that they've got supporting them. I think it's revving up the money behind them. I think it looks like a street fight. And frankly, of all of the legal battles that Trump has right now, this is the one that I have the least amount of passion for from a criminal perspective, even though the DOJ seems to be going after this one the absolute hardest. They really do need to establish that these classified records really do have a national security interest. And with all of the time passing, that argument seems to be dissipating for them.
Although I got to say, the Espionage Act, and I'm sorry, I'm just going to have to paraphrase it because I don't have it memorized. It's, being in possession of documents, not classified documents, that have military value and could be considered dangerous. It has nothing to do with classified. So I keep thinking, espionage is serious stuff. It just doesn't have to be classified. You guys should have a practice called Cherkasky and Cherkasky. Oh, do you?
we have. That's exactly what we do. That's what we do all day.
All right. Thank you so much. I so appreciate that. And I look forward to having you both back.
Thank you, Ashleigh.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.